Hi, it's Mike DelSignore, Massachusetts OUI Lawyer. In today's video, I want to talk about what happens if you're charged with OUI and it's your second offense, and the case is going to be heard in Ayer District Court. Now, Ayer is a court I've been handling cases out of for a very long time. What's going to happen, your first court date, you're going to enter a not guilty plea. You're going to go back for a further pre-trial date. So your first court date isn't your trial, it's a pre-trial date. We'll get all the evidence and we'll try to figure out what the best decision is for you. We'll take a look at the report. I'll go over it, see what other evidence we need in order to fight your case. Many cases where someone's charged with OUI, these are very winnable cases. The government's going to prove the case beyond a reasonable doubt. So that's a high level of proof. So just because you're arrested doesn't mean you're going to be convicted. First thing I want to do is I want to look at your first offense. If it's within the time period of between 2011 and 2019, I may be able to reopen the case if you took a breathalyzer. So potentially I can knock out your first offense and basically give you two first offenses. So what happens, and I've done this quite a bit, is if I can vacate the prior offense, that case still comes back. Generally, we can get that case dismissed, but then you'd have basically two pending cases. And typically what would happen is I would get the first case dismissed and then we could still fight the second case. So I had a client once, OUI second, Dudley, OUI first, East Brookfield. I was able to open the East Brookfield case and then win the case in Dudley. So he came to me with two OUIs and left with no OUI offenses. So that's the best case scenarios. Maybe we could do something about your prior offense. If that's not the case, if you refuse the breath test, if it's too old or past the time period, then I'll look at the case, look at all the evidence, and try to determine what your best strategy is in terms of your defense. So first thing we look at is the driving. In many cases, if there's not evidence of erratic or unsafe driving, we can use the driving to your advantage. In other words, there's always going to be an allegation of some driving usually, maybe a lane violation or something. But if it's very minor or minimal, we emphasize that and try to emphasize any good driving. If you're in an accident, then the strategy is a little different. We'll try to minimize the accident, of course. Accidents happen all the time. They have nothing to do with alcohol sometimes. But then we'll focus on a different part of the case in terms of our defense. We might focus on the fact you were polite, cooperative, respectful. We might focus on the field sobriety test. Now, the field sobriety test, the one-leg stand, 9-step walk and turn, these are tests that are done in almost every case. But the assumption that you are under the influence because you didn't pass those tests is flawed. In other words, there's a lot of reasons. Maybe you were tired. Maybe it was the road conditions. Maybe you have a prior injury. So there's a lot of reasons other than alcohol that can explain the performance on the field sobriety test. And in many cases, when I read the report, I'll basically say, hey, I think you did very well. The officer just didn't score the test correctly. Now many departments have video, and one of the things we see on video quite frequently is the officer just stops the one-leg stand. I've seen many clients, their leg up, and the officer just ends it. And then we see so we have that issue where the person's not even really given a chance to complete the test. And then we have many officers talking during the test. Repeatedly, I see officers continuing making minor corrections and points. They're supposed to give you a chance to do the test. For example, if you're doing the one-leg stand and you're not looking at your foot, if an officer constantly tells you to look at your foot, it's distracting. You can actually pass the test and not look at your foot. They need 2 clues for failure. So if your foot is 6 inches off the ground, you're not hopping, you're still doing very well on the test. So there's different things that the officers do on video, and when it's not on video, they're probably still doing the same thing that could impact the results of the test. So keep that in mind. If you have a case in Ayer, call, text me anytime. I've been handling cases out of Ayer. I've had a lot of success in that court. 781-686-5924. My name is Mike DelSignore. My passion is helping people make the best decisions for themselves when charged with OUI. I'll tell you how to get back on the road, different resolutions. The second offense, you can potentially get back on the road quicker. If the 2 OUIs are outside of 10 years, there's a disposition where you could get what's called a Cahill disposition. So you'd get back on the road with an interlock device. If you took a breath test and your 2 OUIs are within 10 years, I could potentially help you get an early hardship. The only situation where You basically have to win the case. There's very few options. You refuse the test, 2 offenses are within 10 years, and you got to win the OUI offense and then ask the judge to reinstate your license on the refusal. Otherwise, that 3-year suspension, there's no hardship on that. So I handle these cases every day. I'd be happy to help you with your case in Ayer. Call, text anytime. My name's Mike DelSignore. My passion is helping people make the best decisions for themselves when charged with an OUI offense.